Hello, hello, hello. It's Attorney Mike Grevin coming to you from Chicago. As usual, I've been a good boy. I'm rested and ready. We've got a fun one. I have to dig deep on the weekends. I think we're in the appellate court of Delaware. I'm not sure. Karen files her own appeal and argues it. It's everything you think it would be. It really is. And then we've got Jay Regier and company out in Kansas. I have another bit that I might do as well. There's another call that looked very promising, but I didn't have time to chop it up. We might dive into that if we feel like it at the time. Let's get started, shall we?
I'll enter a not guilty plea on your behalf.
Wait, sir, my phone died. Oh my God.
Your Honors, the matter before the court this morning is the case entitled Karen Segalis versus Raymond Knutson and Marilyn Knutson, case number 22AP280.
Ah, yes. It's a good day. We've got a Karen named Karen.
Appellant Karen Segalis is self-represented. Representing the appellees, Raymond Knutson and Marilyn Knutson, is attorney Stacey Adamski.
Okay. Ms. Segalis, can you hear me?
I can hear you.
Okay, great. Oh, there you are. So you can go ahead. You understand you have 5 minutes, and you can save any time you'd like to respond after the appellee responds. So go ahead.
Hi, so good morning, and thank you. So with my 5 minutes, I'd like to take the first half to speak to you, and then you're welcome to ask me questions after, because last time we did this, you guys asked me questions. I didn't really get to speak, so I just want to say I will leave time for questions. So I'm sure you're familiar with the story, but I'm going to give you a first-hand synopsis just as a refresher. Defendants used every single resource they could find, including 4 local police departments, Chittenden Unit for Special Investigations, Homeland Security, FBI, and state attorneys, doctors, teachers, dentists, lawyers, literally grooming professional witnesses with inappropriate financial relationships to try to send me to jail for imaginary and horrific crimes that I didn't commit.
Hi, Natalie Lorchuk. Nice to see you.
So they could forcibly take my child from me. That was the goal, and that's what happened. And it worked. My son is about to turn 18, and he still believes that I am a violent criminal who assaulted him and that I went to jail for it. He believes that he is a sexual assault victim, and I have read in reports that he is well-adjusted and doing well, but what kind of well-adjustment is believing that you are a parental sexual assault victim when you are decidedly not that? My son has been groomed to take every opportunity to be abusive to me, and as such, I suspended visitation to protect both of us from continued irreparable emotional harm directed at me, proxy through him. For the record, I have not had a meaningful conversation with my son where he was not under this influence since 2012, when he was 6 years old. So 11 years later, there has not been a single consequence assigned to Newt, not a single one. So that's a quick summary. Again, I will answer your questions at the end. So the word genocide means forcibly transferring children from one group to another. And this case actually now falls within the parameters.
I don't think that word means what you think it means. But okay, we'll carry on. That's where she sounds straight like Sarah Pike Levy right there.
With that definition, Leif was forcibly removed from me under false pretenses of complete horror. And the actual truth has been under court order to remain that way ever since. As a result, he will likely never meet his maternal family, including uncle, aunt, me, his cousin, his extended family, and his overseas relatives, because he has been conditioned to believe that we are all evil. I really hope to have my day in court to not only remand the hundreds of thousands of dollars lost for me and my family, because I was tried in a family court instead of a criminal court, so no public defender was offered to me, but also so that someday my son would be able to learn the actual truth.
Yeah, it was before the family court because they had proper jurisdiction to decide that issue. It's not a conspiracy against you.
Truth about what happened to him, since the truth is under seal with punishments, if told. The punishments that have only ever been slapped on me, frequently inappropriately and under false pretenses, but punishments have never been assigned to the Knutsons. I am asking for my day in court, and in order for that to happen, I need additional time to secure legal representation. Please. judge did not give me enough time to find an attorney. There was a pandemic that shut courts down for 18 months. And it seems like maybe 18 months would have been reasonable enough time to find a new attorney, but that was not offered. I wasn't allowed the same amount of time because the courts were shut down. So in just over a year, despite pleading with the court on multiple occasions and showing over 50 calls made to demonstrate a good faith effort, it was demanded that.
Okay, so here's the problem. I don't know the underlying situation here. There's some family squabble. They've gone back and forth, but it was in the courts for years, as you will see. She's saying 18 months isn't enough time to find an attorney. Only if your claims don't have merit, to be honest, or you have no money. Those are only two ways I can see that. There is no way. What appears to have happened, again, because all we have is this 10-minute appeal. What appears to have happened is she filed a lawsuit. It got up to trial. She tried to continue it the day of trial. Nobody can do this. Nobody can get away with this. The judge said, nope. She walks out on trial. And my guess is the judge just dismissed the case because she didn't prosecute it, which there's really nothing else you can do. Now she's before the appellate court asking for more time to get an attorney. If you didn't get an attorney in the 18 months during the pandemic, by the way, an easy time to get an attorney because nothing else was going on, you're not going to get it later.
That I litigate my own case, which caused me an abrupt and unexpected trip to the ER for a cardiac workup. Imagine cross-examining your own child who believes that you sexually assaulted him and the abusers who orchestrated this whole thing. It was insinuated that I lied about this, so I sent a copy of my EKG from the hospital. It wasn't enough. I begged for more time, for more representation. So strictly against medical advice, I showed up to close the case. There was no other choice. I was not given enough time to find an attorney. When a pandemic shut the courts down for 18 months, it seems reasonable to be offered enough time. Please, I am only asking for my day in court. And in order for that to happen, I need additional time to secure representation. I'll close with my good friend Kevin Bose taught me to always end a pleading with, and any additional relief that the court might find appropriate. Thank you, and I will take your questions.
I don't see that there are any questions. Would you like to save your 1 minute for rebuttal?
No.
Okay, well, I'll give you that opportunity.
Like this. So she kicks it off by saying, I'm going to give my statement and then you guys can ask me questions. That was earlier. I let it go. But that's not how it works. You're before a panel on an appellate court. They can ask you questions anytime they damn please. They did stay out of the way. Then they didn't even have questions for her. She has a minute left. Would you like to save that for rebuttal? No. Why not? I mean, you don't have to use it. and then the justice or whatever says, well, we'll reserve it for you anyway. I'm sorry. That might just be an attorney thing, but it was too fun for me.
In any event, after we hear from Ms. Adamski. So, Ms. Adamski, go ahead and introduce yourself and your client and proceed.
Thank you, Your Honor. My name is Stacey Adamski, and I represent Marilyn Knudsen. I am here on behalf of both Marilyn and Ray Knudsen. I will be making the argument for myself and for Attorney Rob McClellan. After hearing appellant's arguments regarding the history of the case, the one issue that is very clear is that none of the allegations that she has made have ever been proven in court. We were on the verge of a 5-day jury trial. We had paneled a 12-person jury with 3 alternates on that day. They were at the courthouse waiting to proceed.
She explains later.
The appellant then filed a motion to continue on the Friday before the 5-day jury trial was supposed to continue at 2 or 3 o'clock in the afternoon was when I received it. She then gave a document purporting to be her EKG without any sort of medical evidence about what that EKG represented or how it impacted her or why it would give the court cause to continue this jury trial. Prior to the jury trial, both Attorney McClellan and I had subpoenaed witnesses. We had prepared our witnesses. We had filed motions in limine. We had filed jury instructions. Any delay at that point would have had a significant impact both on the defendants and on the court for time. The appellant, while giving a story that she believes to be moving and believes to be draw the court's empathy, ignores the fact that what she's asking for is for this court to overturn decisions made by the trial court, which were well within the trial judge's discretion. There is no argument or no support for why any of this should take place. There's nothing in any case law that suggests that the appellant is entitled to an attorney or that she would have more time to secure counsel. There's nothing that suggests that if the court were to have given her an additional delay after the year that she had, that she would have been successful in getting new counsel. And there's nothing to suggest that any sort of delay would have done anything other than kicking this can that had been on the court's calendar for 7 years. To any further
that's on the civil court's calendar for 7 years, but it had been on the family court calendar for much longer than that.
For 15.
Asking, isn't that sort of?
That's right, people. We've had 2 actions going, one for 7, one for 15. And she's crying about not having a chance to have an attorney. By the way, she had an attorney who withdrew, and she agreed with it. Probably because the attorney said, you know, this is a bridge too far. You're trying to get me to make arguments that don't make sense. That is my guess.
Doesn't that sort of support Ms. Gallis's request? Because this is a highly complex case with
oh, here we go. I don't know if this guy's playing devil's advocate or he really believes it, but he's saying, you know, this is a highly complicated case that she can't handle. We all agree with that. The other thing she can't do is just walk away from a trial with jurors impaneled the day of trial on some trumped up BS. Otherwise, you don't have a system whatsoever. The defendant has rights here as well.
Significant amounts of accusations on both sides and difficulties with a lot of difficult emotions and facts that were highly in dispute, if I read it correctly. And that for her to do this on her own isn't at the end.
Absolutely. Here's the other thing too, where I can just tell this is an irrational crusade. The kid's 18. If you want to rekindle your relationship with your child at this age, it's just up to them. That's all there is to it. There's nothing else. Even if a judge comes in and says, "Okay, you must talk to your mother" or something, which they wouldn't. It doesn't matter. It's not enforceable. That's that. So we're past any of this mattering.
End of somebody's ability to handle a complex case like this.
Well, I certainly don't disagree that it is a very complex case, but there are 2 questions at play here. One is whether or not she's entitled to have counsel. We do not know why her former counsel withdrew with attorney Ms. Gallis's permission. We also don't know that she would ever be successful in getting new counsel. It could be that the people that she contacted read and reviewed the case and said, "We don't think that we want to take on this case, or we don't think that your arguments have merit." I mean, this case pending in both the family court and the civil court, a lot of things have changed since the case first came to this court's opinion. And one are issues and arguments that are made in the family court, including sound recordings that.
By the way, warning, we don't get a ruling. This is an appellate court. This is argument. Appellate courts just don't issue rulings right afterwards. They issue rulings. They issue written rulings by and large later after their clerks draft them. That's how it works.
Judge Corzone's put on the record and read into the transcript. I mean, this is not a case.
That's Judge Nancy Corzone's, correct? Just so the record's clear, it's just Nancy Corzone's.
Judge Corzone's, Your Honor.
My overwhelming guess is, despite this guy playing devil's advocate here, that her appeal gets denied, and the ruling of the first court gets affirmed.
I believe it was Cortland.
There's two Judge Corzone's. I just want to be clarified that it's Judge Nancy Corzone's.
My understanding, and I was not in the family court hearing because I did not represent, my client was not a party to it, but my recollection
you have 1 minute remaining.
Thank you, Your Honor. This was a family court decision that was made within the past 18 months to 2 years, Your Honor.
Oh, this is a recent
one that had a sound recording in it that makes this case not as black and white as Ms. Gallis wants it to be. That this this, that the Knutsons have made somehow brainwashed their child. It is not that case, but her time to make these arguments and to have these conclusions before the court to secure her her day in court as she's requested was given to her, and it was given to her with 5 days, and then she refused to move forward. She was told and given the opportunity to proceed, and she told the court that she wanted to go home. The court gave her very clear instructions on what would happen if she did not proceed, and the case was dismissed appropriately.
Okay, thank you. Thank you so much. And bailiff, Ms. Sagalis has 1 minute remaining. Is that correct?
Appellant has 47 seconds remaining.
Okay. Go ahead, Ms. Sagalis, if you'd like to.
I'm okay. I was not able. I couldn't listen to her. I muted her. So I have no idea what she said. Doesn't matter.
So just to be clear, you could have listened, but you chose to mute?
I am so emotionally ripped apart right now that I can't even hear what she has to say, because what comes out of her mouth is a representation of lies and manipulation.
Okay, thank you.
Physically
attacked me. All right, the bailiff may call a close to the case.
We had guys who were altercation, Your Honor. There's no such thing as that. You got into an altercation. About what?
23 CR 227. State appears by Assistant County Attorney Jared Regier. Mr. Hunt appears in person by Zoom.
This is kind of fun, but it's a departure for Law Talk with Mike. All the defendants are pretty rational and make good sense here. So it's something you're not going to be used to.
Hunt, we're here for a first appearance. Looks like you were arrested and posted bond. Did you receive a copy of your charges?
No, Your Honor.
All right, I'm going to go over those with you. There are 3 counts. And do you have a pen and paper?
Yes, Your Honor.
Okay. Each one of these 3 counts is alleged to have occurred on April 30th, 2023 in Butler County, Kansas.
I got to get back to Gushati Court.
Count 1 alleges that you were in unlawful possession of marijuana. That is a Class B non-person misdemeanor. Count 2 alleges that you were in unlawful possession of paraphernalia for use. For being in possession of a clear bag. I'm assuming the bag was used to store the marijuana. Those are both Class B non-person misdemeanors. They carry a maximum penalty of 6 months in jail and up to a $1,000 fine. Count 3, you're charged with speeding 75 in a 65 mile an hour zone. That's a traffic infraction, and that carries a statutory fine. Do you understand what you've been charged with, Mr. Hunt?
Yes, Your Honor.
And how do you intend to proceed on your case?
I would like to request public assistance.
Okay, you wish to apply for court-appointed counsel?
Yes, Your Honor.
All right, so you
Okay, so he didn't know the right thing to say. I want to apply for court-appointed counsel. He said public assistance, but this is typical. Like, just because you're not an attorney doesn't mean you can't say things in plain English and we won't figure it out. It's a rational request. It's the right thing to do. We'll translate in a courtroom. We'll translate from rational request in English to law. That's not a problem. That's what I'm saying. This guy actually makes sense.
You can't afford to hire your own attorney?
No, Your Honor.
All right. Are you currently employed?
No, sir.
And how long has it been since you worked?
It's been 7 years since I was a disabled veteran.
Okay. So you receive veterans disability?
Yes, sir.
Okay. I'll appoint Darren Patterson to represent you. He's an attorney in El Dorado. I can provide you with his phone number.
Finally gets a decent client.
Thank you, sir.
Area code 316.
Good for you, Darren. This guy will listen to you.
322.
You'll resolve that one quickly.
7700.
You deserve it, brother.
All right. Your next court date will be July 31st, 2023 at 8 o'clock a.m. in front of Judge Webster by Zoom. July 31st at 8 o'clock a.m.
That'll be a plea,
Yes,
Darren.
sir.
What
All approved. The bond
We'll get
that you posted through
resolved.
AAA.
Not much will happen, and he'll be
Where
fine.
do you reside, Mr. Hunt?
In Longton, Kansas, sir.
Longton?
Yes, sir.
All right, you need to call Mr. Patterson's office when we get done here today
That would be cool.
and give them your court date and contact information, and make sure that you stay in communication with him between now and your next court date.
Yes, sir.
And then again, you'll be appearing by Zoom. Your internet connection seems pretty.
I called Regier, but he didn't call me back, and I'm not sure. I'm not sure, but I think Jill Gillette answered the phone because I called the office. She asked if she could do anything for me, and I was too. I didn't want to freak her out and ask her if she was Jill Gillette. That's the truth. That's the behind the scenes truth, people.
Solid here today. So, do you have any questions?
Yes, sir. Can I have my case number once again, please?
23 CR 227.
Yeah.
All right, thank you, sir.
And Mr. Hunt, as a condition of bond, you're not to possess or consume alcohol or illegal drugs.
Yes, sir.
All right, Mr. Regier, anything else on Mr. Hunt's case?
Your Honor, I have a note in the file which would appear to suggest this defendant may or may not have applied for diversion recently. Given that the court has appointed Mr. Patterson, in this case, I would respectfully suggest any further communications to my office should go through the defendant's attorney.
All right. All right, you're nodding in that you understand, Mr. Hunt, since you are represented by counsel, just allow Mr. Patterson.
By the way, that's helping the defendant out here. He's saying what he's saying is he's calling over here. I'm afraid he might say something stupid. Just let Darren close this. That's Regier. It doesn't look like it, but he's trying to be helpful.
Or his office to further communicate with the county attorney's office if you have in fact submitted a diversion application.
Understood, Your Honor.
All right. If there's nothing further, we'll be in recess. Mr. Hunt, you are excused. Thank you.
Thank you, sir.
All right. Next case, Euribio Perez.
Oh, hello.
Judge Crum, by the way, is so dry, but he's low-key funny, but no one gets it because he's so he's so straight-laced that no one sees it when he's doing it.
Mr. Perez?
Yeah.
Right, I was getting. Do you have two devices hooked up?
Excuse me?
Do you have two devices hooked up? I'm getting an echo.
I don't know. My speakers, I can hear y'all, but they're not like good speakers, you know. On my phone.
Can you hear me now?
Yeah, I can hear you good.
Okay, I'm not getting the echo anymore.
Okay.
I might ask that if you could hold steady like you are now instead of moving around it.
This guy's also pretty rational, despite the haircut.
I pronounce your first name correctly?
It's Rubio Luna Perez.
Okay. We'll go on the record in State of Kansas versus Rubio Luna Perez. Case number 23 CR 108. The state appears by Assistant County Attorney Jared Regier. Mr. Perez appears in person by Zoom. Mr. Perez, you're appearing by way of a summons. This is a first appearance. I'm going to go over your charges with you at this time. There are 5 different charges, each alleged to have occurred on July 1st, 2022 in Butler County, Kansas. Count 1 alleges that you were in unlawful possession of marijuana with the intent to distribute. That is a level 4 drug felony. Count 2 alleges that you are in unlawful possession of paraphernalia to distribute or manufacture. That is a level 5 drug felony. The paraphernalia item looks like was a scale. Count 3 alleges that you operated a motor vehicle upon a highway.
Mental health with marijuana. Only thing is going on is that maybe when you high, you don't be thinking about your mental health.
Without having a driver's license in your possession.
I know the pot smokers are going to go crazy on these people getting charged with marijuana possession.
That is no driver's license in possession.
Turns out that's the law in Kansas, however.
That is an unclassified non-person misdemeanor. Count 4 alleges that you operated a motor vehicle on a public highway in Kansas without having proof of insurance. That's no proof of insurance, a Class B non-person misdemeanor. Excuse me. And count 5 alleges that you were speeding 60 miles per hour in a 30 miles per hour zone. That is a speeding traffic infraction. Do you understand your charges, Mr.
Yeah, I
Brown?
understand. Yeah.
Do you have the finances to hire your own attorney?
No.
You wish to apply for court-appointed counsel?
Yeah.
Who are you communicating with there, Mr.
Oh, it's because it's my mom's friend. I kind of don't know the big words for court, you know. So
Okay.
she's just trying to, yeah.
Well, I'm just going to ask that you not receive any outside assistance right now, but are you currently employed?
Yeah.
Or where do you work?
Gutters. The company is called Rainwater.
And where is that located?
Well, we just go around Wichita doing people's gutters, like fixing them up or getting them new gutters or downspouts and stuff like that.
Yeah, it's not like they have a big office space downtown. Oh, this is funny.
How long have you worked there?
Once I got out of jail, I started working there. So ever since July 4th, I think. Yeah.
Of last year?
Yeah.
What's your approximate gross monthly income?
$1,500 a month.
Good. Do you work full-time hours?
Well, it just depends on how many houses we have that same day. Or he would just move the houses to the next day, you know.
All right. I'm going to appoint James Watts to represent you. He's an attorney here in El Dorado.
And a good one.
Do you have something to write with?
Yeah.
His phone number is 316.
Yeah.
452.
452.
5640.
5640.
Correct. And I'm going to set your case in front of Judge Rickey on his July 3rd, 2023 at 2:30 felony preliminary hearing control docket. July 3rd at 2:30.
Your Honor?
Yes?
I'm actually showing an appearance bond in the file. It looks like it was professional surety. It's somewhat unusual in that it looks like it has a date of July 3rd of 2022 with an appearance date of July 8th of 2022. However, it looks like going off the affidavit, it looks like the stop had originally occurred back on July 1st of 2022. So I'm not quite sure how the court wants to address that or not.
Well, I'm assuming that he bonded out, went to his first appearance, and charges weren't filed at that time. I'll establish a bond for you, Mr. Perez, in the amount of $2,500 OR. Since you've appeared here today on your summons, you've got an attorney appointed. We've got a bond set. You have a new court date. You are going to have to make arrangements.
See, it's a miracle. You show up and act like a normal human being, and you get a own recognizance bond, and get let go. Even though there's some funky stuff going on.
Wants to come over here and sign your OR bond. Do you live in Wichita?
Yeah, I live in Wichita right now.
Okay, Jarrett, what does he need to do to make arrangements with you?
Just come in whenever you're coming as soon as possible, but whenever you're close to El Dorado, stop in at 201 West Pine, and we'll have it at the front desk. Just tell them that you have paperwork that needs to be signed.
Does he need to do that today or?
Whenever he can. Yeah, if he can get here before 5 today, he can.
So what do I need to do exactly? So go to there and just get my paperwork?
Yeah, I already have everything filled out. You just have to sign a couple things.
Okay. So what's the address again? 201
West Pine.
All right. Yeah, I got it.
Okay.
Mr. Perez, can you make it over to El Dorado today?
Let me see. I could try. Yeah, I could probably try. I just need to find the ride.
All right. If you can't make it today, can you make it on Monday?
Monday? Yeah, I'm free Monday. I could. If anything, if I can't right now, I could go Monday.
All right. Why don't you try to make it over here by 5 o'clock on Monday?
I'm not gonna lie.
That's the 8th. That gives you plenty of time to make it over here to sign your bond.
But he seems a little high right now.
I was gonna say the new court date. You just gave it to me, right? Or does it come in the mail again?
Well, it's July 3rd at 2:30. I don't know if it'll come in the mail. You've got an attorney, Mr. Watts, has been appointed. You need to call his office when we get done here today.
Yeah, I just call him.
Give him your contact information. That way he can be in communication with you and help you get the Zoom link and work on your case.
I appreciate it.
All right. Anything further on this case, Mr. Regier?
Yes, Your Honor. In light of the charges filed in this case, I'm not sure if the court wants to make it a special condition of bond that he'll both have he'll have no contact with illegal drugs or alcohol, as well as he will not drive illegally.
All right, Mr. Perez, as a condition of bond, you're not to possess or consume alcohol or illegal drugs, and don't operate a motor vehicle unless you're properly licensed, insured, and have all of your documents in your possession.
So can I still try to get my license and stuff if I do it, like, you know?
That's beyond the purview of what we're doing here. That's between you and the Department of Revenue.
Okay.
If you're able to get your license reinstated, if it's not, then that's probably in your best interest, but I wouldn't suggest driving if you're not properly licensed.
Yeah. Okay.
All right. Anything else?
No, that would be it. Appreciate it.
All right. We'll be in recess. You are excused, Mr. Perez. Thank you.
You're not appearing in court.
All right. London Cooley.
London Cooley, everyone.
Are you able to hear me?
Yes.
All right. Next case on the docket is State of Kansas versus London Tashell Cooley. Case number 23-CR-215. The state appears by Assistant County Attorney Jared Regier. London Cooley appears in person by Zoom. Miss Cooley, rather, this is a first appearance. Apparently, you appear here after receiving a summons. There's just one charge alleging that on April 17th of this year in Butler County, Kansas, that you did unlawfully and knowingly violate a order out of Butler County District Court Case 22-CR-450, in which it was a condition of bond not to have contact with Jeremy Brown. That is violation of a protective order. That's a Class A person misdemeanor. That carries a maximum penalty of 12 months in jail.
Just couldn't stay away from downtown Jeremy Brown.
and up to a $2,500 fine. Do you understand what you've been charged with?
Yes.
All right. And how do you intend to proceed on your case, Ms. Cooley?
Well, I had just gotten out of jail the first four.
Ms. Cooley, I don't want you to say anything that incriminates you. I just need to know, do you understand the charge against you?
Yes, sir.
Okay. Do you wish to, are you going to consult with an attorney? You can enter a not guilty plea. If you wish to consult with an attorney, you could enter a guilty plea today, or you could enter a no contest plea today.
Could I have Josh Andrews for my attorney?
Right. So you wish to apply for court-appointed counsel?
Sir.
All right. I'll enter a not guilty plea on your behalf.
It shocks me the number of defendants that think they can name their attorney. I mean, she isn't out of hand. She expressed her preference, so there's nothing so bad in and of itself. But it's like, no, let's just get court-appointed counsel, and then you get who you get. That's how it works.
Sir, my phone died. Oh my God. Could I have Josh Andrews for my attorney?
Right. So you wish to apply for court-appointed counsel?
Sir.
All right. I'll enter a not guilty plea on your behalf.
Sir, my phone died. Oh my God.
Look at the expressions. It's good.
And don't forget to hit like and subscribe, or the dogs get it.
3 straight-laced uptight dudes. Like, we got nothing.
Miss Cooley? I hope she has a charger.
Judge, if I may, while we're waiting on Ms. Cooley, Texas has withdrawn their extradition warrant, so Ms. Flakio is going to be released here shortly.
Okay, thank you.
You're welcome.
Have you had any contact from London Cooley?
No.
I'm going to give her a few minutes. Jared, do you show any other cases after this London Cooley case?
Not to my knowledge, Judge.
Miss Cooley?
Yes, sorry.
Miss Cooley, that's not a very good connection. I can barely hear you.
Oh, it is. Okay.
That's a little bit better. Are you able to hear me?
Yes.
All right. I don't know if we went off the record, but we're still on the record in State versus London Cooley. I advised you of the charges. I'm not sure where we were when you got cut off, but
we were talking about a lawyer or plaintiff.
You wanted to have Josh Andrews. Does he represent you on other cases? Or
yes. Yes.
You have other pending cases in Butler County District Court?
Yes.
All right. Are those set in front of Judge Webster?
Not for sure. It's for next month.
All right. Mr. Regier, do you have any information about other pending cases she may have?
He's trying to figure out if they're misdemeanors or felonies without asking if they're misdemeanors or felonies. I can see it all day.
One moment, Your Honor.
Judge, she has 3 cases in front of Judge Webster.
Look at that.
Okay. Are those all set on one date, or are they spread out?
Cogitating circle over it.
Your Honor, it looks like at the very least, this defendant has a case before Judge Webster on July 5th, and it looks like Mr. Andrews is the counsel of record in that case.
Is that at 9 o'clock?
I believe so, Your Honor. Looks like There's another case, 22 TR 2399. Looks like Mr. Andrews is also on that case, and that also appears to be next before the court on June 5th at 9.
June 5th?
Yes, Your Honor.
And the other one's July 5th?
Forgive me if I misspoke, Your Honor. Both those appear to be on June 5th.
Okay. And Mr. Andrews was appointed on both?
And Your Honor.
It would appear so, Your Honor.
Go ahead.
And also on May 3rd, 2 days ago, I had court, I guess, and a summons that I had not gotten for 222 TR 4239 for first appearance.
Okay, I don't know anything about that case, Miss Cooley.
She has a bench warrant.
Yeah.
Have you ever had a failure to appear?
Possibly.
Let me take care of the business on this case first.
Okay, sorry.
I will appoint Josh Andrews to represent you on this case, and I will set this case along with those other two on June 5th at 9 o'clock back in front of Judge Webster. So that way all three of those cases will be there on the same date and time.
Okay, just funny.
We need to establish a bond in this case. What is your recommendation, Mr. Regier?
Your Honor, the state would recommend 5,000 OR. I believe the court has already spelled out the facts quite clearly, but for purposes of the record, it looks like this is a case involving a no contact order as part of a bonding conditions in another Butler County case, which this defendant does not appear to be adhering to. So I believe that the state believes that a 5,000 OR bond at the very least is appropriate and with all standard conditions.
All right, Ms. Cooley, I will order a $5,000 OR bond on this case, which means you don't have to pay a bondsman or put up cash. You'll just have to sign your own name. If you fail to appear, you could have to pay $5,000 into the court. As a condition of bond, you're not to have contact with Jeremy Brown. I know he keeps coming back in front of the court for the same issue. You two are not to have contact with one another.
Right. And I'm not doing that no more. I'm sorry.
Okay, well, I'm just warning you, that's a condition of bond.
Okay.
And I don't know what your other charges are, but it could result in additional criminal charges. You'll need to make arrangements. I don't know what you'll have to either turn yourself in on that bench warrant.
Okay, yeah, I'm gonna.
Okay, perhaps you can do that and sign your OR bond at the same time.
But I can't be sharing it.
Can you make it to the courthouse today by 5?
Yes.
Are you in El Dorado?
Yeah.
Okay. Then you can make it to the Judicial Center?
Yes, by 5.
Okay.
Actually, Your Honor, if she could get here by 4:30, that'd be great.
Okay. You don't want to be stuck there after 5 o'clock?
Well, we got other things going on at the same time.
I understand. Can you be there?
I doubt she shows up because now she's got a warrant. So she gets an OR bond, which is dumb because she should go and they probably won't do anything to her. But they might just throw her in jail for the warrant.
There by 4:30, Miss Cooley.
Yeah.
That's an hour and a half.
Okay, yeah.
Okay.
Yes, sir.
That'll be the order of the court. All right. Anything else on this case, Mr. Regier?
Nothing from the state, Your Honor.
Did you have additional questions, Miss Cooley?
So whenever I get there, I can OR, right?
You can on this case. I don't know what's going on with the outstanding warrant. So they might have to take you out to the jail and process you on that. I'm not sure.
Correct. If there is a warrant, she will have to be taken out to the jail.
I'll take that as a no.
Okay. Okay, thank you.
All right. Anything else on the London Cooley case?
I do need to speak to her about getting processed on this case, though, so I do need to talk to her for a little bit.
You want to do that in a breakout room?
That'd be great.
All right. Do you know how to do a breakout room, Miss Cooley?
No, I don't.
You'll get a prompt that says join, and then that'll put you in a private conversation with Deputy Spickler.
Okay.
Hey, Your Honor?
Judge, I don't know that we're going to have time for that because we got to go right into the hearing.
Okay. Yeah, we have a 3 o'clock hearing waiting in the courtroom for us.
Right.
Full-face jokes are strictly prohibited.
It might be good if she's going to turn herself in on the warrant, she just drive out to the jail. That way her vehicle will be out there when she's out there. That'd be fine, because I'll fax this, but I'll talk to her separately.
So go to the jail, right?
Hold on.
Go to jail.
They're going to put us in a breakout room. Just wait.
Okay. Sorry.
All right. We don't have can you do that fairly quickly? We've got to be in the courtroom.
Yes.
So,
yeah.
All right. We'll be in recess. All right. Thank you, everyone.
Oh, puppy.
Yes, Paul Burschauer, Municipal Jail.
Good afternoon, Mr. Burschauer. Looks
Good
like
afternoon,
we
Your Honor.
are on for an arraignment.
All right. Tell me if you can't hear this.
And
this is live. I didn't have a chance to chop it up.
Good afternoon, Your Honor. This is Defense Counsel Michael Peck appearing for the defendant, Mr. Paul Burschauer. I have spoken to the defendant this morning. I had advised him his rights, and so we can go ahead and waive the formal reading of his complaint and the advisement of rights. We'll stipulate to probable cause for this arraignment only and enter a plea of not guilty today.
Okay, thank you. Based on that stipulation, I do find probable cause. I will enter a plea of not guilty.
Thank you.
I'm sorry. Okay. Apparently the court did not get any paperwork over here. Do we need appointment of counsel?
That's correct, Your Honor. He does qualify for indigent defense.
It's giving me the heebie-jeebs.
I do not have a list here.
I haven't seen this judge before. I've only seen a few minutes, but he's got potential. He's got a little bit of crank in him. Not too bad, just a little bit, which enough to make it fun.
Okay. Well, at least for the moment, I'm going to appoint Brooks to Pizer. In part because I do not have my list to tell me who would be next on the list. So
he's different, but
that appointment, and I'll hear from the city on conditions of release.
He puts me in mind of Arth a little bit, which
Your Honor,
to me is a compliment.
In this case, no objection to having Mr. Burschauer released on his personal recognizance. The city would request conditions not to commit any law violations, not have any contact with the Home Depot.
Okay. I'm not hearing any objection to those conditions, and they are fairly minimal, so I would be inclined to grant them anyway. Mr. Burschauer.
Yes, sir.
I will be releasing you today unless there's something else that's holding you there. But you're not to have any criminal law violations. You're not to have contact with Home Depot. And I have a mailing address for you on Rich Road. Is that a good mailing address?
Yes, sir.
Okay. So what we're going to do is we're going to mail out the notice for the next hearing.
Okay.
And your attorney will be Mr. DePeister. The jail will be able to get you information for him. I'll be signing an order to that effect here in just a moment.
Okay, thank you, Your Honor.
Actually, give me just a moment, sure. Okay, actually, we are going to give you your next hearing right now. It will be Tuesday, June 13th at 10.
Tuesday, June 13th at 10.
For a pre-trial, and that will be on the order I'm signing as well.
Okay.
Did the court get a phone number for Mr. Bershauer? If so, I can try to provide that to Mr. DePeister as well, just in case he can reach out to Mr. Bershauer before he does.
Mr. Bershauer, do you have a cell phone where you might like to get
Yes, sir.
text message reminders?
Yes, sir. It's 564-464-8678.
8678?
Correct.
Okay. Okay. I'm signing that order now. All right. That will do it. Thank you.
All right. Thank you, sir.
I still don't see Ms. Langley.
Thank you, Casey Cat.
Yeah. Clatouche?
Your Honor, this is a different person, Mr. Clatouche.
Dale Clatouche?
Yes. Yes, sir.
Okay. Looks like we are on, there was a warrant. I do see you've been advised of your rights. And do we have an attorney here for Mr. Clatouche?
Yes, Your Honor.
Okay, thank you. Have you had an opportunity to speak to your client?
I have, yes.
Okay, and what would you like me to know here?
So, based on my understanding, defense's understanding, Mr. Clatouche did not receive notice of this. This, as you can tell, the warrant was issued quite some time ago. Let me start with when this case originated from, which was 2020, August of 2020. The warrant was issued following a hearing in 2021, I believe, where the assigned attorney was not present. It's my understanding that Attorney Schuler had represented Mr. Clatouche prior to that hearing, where the warrant was issued, and then at the hearing where the warrant was issued on
Agreed. I like me some Attorney Lesh.
September of 2021. Mr. Clatouche was represented by Attorney McDonald. Based on Mr. Clatouche's statements to me, he did not receive notice of this. I know that during COVID, there was a backlog and hearings were canceled and reset. And he has been informed of the warrant in Grays Harbor, which he also did not know of. And as soon as he is released, if that should happen, he is going to call Grays Harbor and get that cleared up.
PD by day, librarian by night.
Okay, thank you. Any input from the state?
Yes, Your Honor. The state is not comfortable quashing the warrant. This warrant was issued after more than one failure to appear at the compliance review for a pretty severe DUI. He's also failed to comply with the treatment obligations and the jail obligation. He has his history makes us concerned. He has 2 guilty findings for bail jumping, a recent guilty finding for failure to register, and a more recent open charge for failure to register. Also, of course, the open warrant out of Grays Harbor and several past warrants.
Your Honor, may I have the opportunity to respond?
Certainly.
Thank you. I would like to point out, while Mr. Klotush does have a few failure to appears, there are only 2 out of Thurston County District Court. The court we're in here today. The most recent one was September of 2021, which is over 1.5 years ago. And that's the warrant that we're taking care of today. Prior to that, the prior was about 2 years ago. There are some old warrants, again, only 1 out of Thurston County District Court, and that was issued over 2.5 years ago. All of the Superior Court warrants, which are inactive now, were from 2012 or before. I think it is pertinent to take time into consideration. And in addition, the state mentioned the 2 bail jumping cases. While those are concerning, they were from 10 years ago, over 10 years ago, and the majority of his record consists of traffic infractions.
Ms. Lesh, what can you tell me, if anything, about the status of any compliance?
He did fully complete the scram requirement in 2021.
He completed his scram requirement. I mean, you know, it's good. But he's supposed to.
What was the non-compliance here? What was the basis for the non-compliance here, I guess is what I'm asking.
At one point, there was a non-compliance of the scram. That non-compliance was in 2020, the end of 2020, and the scram
motion and affidavit now. Okay, Mr. How do you say your last name, please?
Klotush. Yes.
Klotush?
Yeah, Klotush.
Okay. Klotush. All right, Mr. Klotush, I'm going to take a chance on you today. I am going to release you.
Good.
That doesn't change the need to get absolutely everything done that might still be required. You will also need to be addressing that Grays Harbor warrant.
Yes.
Looking through here, I am not seeing, and perhaps the state can update me on this, I'm not seeing chemical dependency evaluation. I'm not seeing victims impact panel. These are things that need to occur. And if they aren't turned in pretty quickly here, you're just going to wind up with another warrant and wind up right back where you are. And I don't think you want that.
No, no, sir, I don't.
So what I'm going to do is I'm going to quash the warrant. I'm going to release you. But I want you to contact probation within 48, well, within 2 business days. Today's already Friday. There's a telephone number on the order I'm about to sign.
Okay.
Call them, even if you just leave a message, even if it's after hours, call them absolutely the first chance you get, because they're going to be keeping an eye on whether you get the rest of those conditions taken care of. And if you don't, you'll, like I already said, you'll be right back here.
No, sir, I'm good with that. And I actually do have my cell phone in my property with me, so I can call them as soon as I get released. So.
Okay, and we're going to give you a compliance hearing of June 22nd at 10.
June 22nd at 10, okay.
Yep, that'll be on the order as well.
Okay.
And I can tell you, even if it isn't me, even if I'm not the judge that day, whichever judge it is, it's going to go a heck of a lot better for you if you show that you've done the chemical dependency evaluation and the victims impact panel. What would be the official pre-FTC? Okay. Okay. All right. I'm signing that order now. You'll get a copy before you're out of here. Well, before you're out of there, you aren't here with me in the courtroom.
Yeah.
Don't make me regret taking a chance here, okay?
I won't. Is it possible, because how I don't have a vehicle and stuff, that I would be able to do the chemical dependency and impact panel through my tribe, and then they could fax it over to you? Or do I have
I'm
to go
not positive, but I think your tribe has court certified options available. Not positive. I know they used to, but I don't know what the current situation is. So it is very possible you'll be able to do that through your tribe and get it sent over to the court.
Okay.
Okay. All right.
Thank you, sir.
That'll be it for today. Good luck to you. And get that Grace Harbor warrant taken care of.
Yep, I will as soon as I get out of here. I'll call in to you.
Okay, thank you. And Ms. Squally, your name, please.
Anastasia McDaniel.
I haven't seen this, but it has promise.
Anastasia McDaniel. Looks like we're on for arraignment, and I'll hear from counsel.
That's correct, Your Honor. Defense counsel Michael Peck is appearing for the defendant, Miss Anastasia McDaniel, regarding her arraignment on theft. I spoke to the defendant this morning. We'll waive the formal advisement of rights and the formal reading of the complaint. We'll stipulate to probable cause for this hearing only, and we'll enter a plea of not guilty and ready for conditions of release.
Okay, any discussion on court-appointed counsel?
Yes, she does qualify for defense, and so she would need a court-appointed counsel today.
Okay, thank you. I still don't have a list here. Although Mr. DePeister doesn't he have more than one contract?
I think Miss Langley might. I think it'd probably alternate back to Miss Langley.
Okay. Well, yeah, let's assign Ms. Langley for the, since I don't have anything else with me, I guess I'll just go back and forth between the two unless I have a reason. Okay, based on stipulations, I will find probable cause, enter a plea of not guilty. I have appointed counsel and I'll hear from the city on conditions of release.
Your Honor, city is recommending that Ms. McDaniel be released on her personal recognizance to come back at future hearings, asking for conditions not to commit any law violations and not have any contact with Home Depot.
Okay, not hearing anything further from Mr. Peck. Those are your conditions of release. No criminal law violations, no contact with Home Depot. Okay, June 26th will be the next date for Ms. Langley at what time?
9 o'clock.
At 9 o'clock. And I am signing that order.
Thank you, Your Honor.
Thank you.
Thank you.
And I believe that concludes my docket. If there's anything else.
I'm not sure because I haven't been through this, but I
think
saw
the
one.
last Lacey matters that Mr. Alvarenga Torres, and I've been trying to connect with Miss Langley. I think it's her client. I don't think she worked out with Mr. Peck to
where I'm guessing
cover. So I don't think there's anything
this
else
gets a
for
lot
him.
worse.
And if we don't see Miss Langley, then unfortunately we may be in a position to have to reset those matters. I know there's an interpreter present, ready to help and assist, but
Thank
I don't
you.
want to have her have to wait the whole entire calendar if we can avoid that.
Yes, I would prefer to avoid waiting the entire calendar. Ms. McDaniel, that will be it for this afternoon. The jail will get you a copy of the order I signed. It has your next court date on it.
Okay, thank you, Your Honor.
And let them know that Ms. Langley will be your attorney. They have her contact information as well.
Okay,
All right. Thank you.
you're welcome. Thank you.
Mr. Peck, unless you have heard from Ms. Langley arranging coverage.
Yeah, I haven't spoken to Miss Langley. I didn't speak to this individual thinking that Miss Langley was going to provide coverage for this, but yeah, I have nothing further to add.
Okay, then nice to sort of meet you and have a good afternoon.
You too. Have a good weekend, Your Honor. Bye-bye now.
And for the interpreter, we are still hopeful that Ms. Langley will be joining us soon. If we haven't contacted her in the next, probably about 20 minutes, 30 minutes, I'm just going to say we aren't going to make it to that today. And you'll be obviously paid for the time you were here, but I'm not going to keep you all afternoon hoping that maybe she will turn up. So we are trying to contact her, and as soon as we do, we'll take that case wherever we are on the calendar. Okay, over at the Arc, who do we have there?
And we're walking. All right. Not this one, but the next one
perhaps Elizabeth Lovato?
Looked out of control.
No. Who do we have?
Amber Schaefer.
Amber Schaefer. Okay, I do see the advisement of rights. And based on the information provided, I will be appointing the Thurston County Public Defender's Office to represent you, Ms. Schaefer, and I'll hear from counsel.
Thank you, Your Honor. We are stipulating probable cause solely for the purposes of today's proceedings. We ask that the court not enter a plea of not guilty, since this is not an arraignment. And Thurston County Public Defense has already been appointed.
And now that I've looked down at the paper copy of the calendar instead of the computer, I can see that. Okay. So how are we proceeding today?
Your Honor, this is Rudy Bretler, DPA on behalf of the state of Washington, if you'd like to hear. Your Honor, the state's going to be filing a motion to revoke on the open case. That's 23DV0507. We were just in court on that case, I think 2 days ago. Ms. Schaefer was issued a no contact order. That no contact order was explained to her in court. She was in custody. I'm sure she had the opportunity to discuss it with counsel afterwards. I don't find any credible basis on that she didn't understand the basis of the no contact order. In this case, she's alleged to have gotten out of jail and gone straight to the protected party's house, gone up to his house. He has video of her at the door, and I have reviewed that video. It's a very solid case. Based on all of that, I think there's a clear reason to revoke her conditions of release on the open case and impose a bail on this matter. Now, I have taken a number of mitigating circumstances into effect. I think in a lot of cases like this, I would probably ask for a fairly significant bail. Here, all I'm asking for is $5,000 on the open case and another $5,000 on this case for a total of $10,000.
Thank you. Turning first to the new case, I believe there was a stipulation to probable cause on that. Based on that stipulation,
Do you see why I suspect the next hearing might be really good?
I do find probable cause. And give me just a moment here. I want to take a look at something. Ms. Lesh, if I were to release your client with bail, if I were to put $2,500 on each, and you might not have this information, but if I were to, do you think your client would be able to post?
I certainly do not. And I would like the opportunity to respond to some of the things the state mentioned. The state mentioned that Ms. Klatush had Ms. Schaefer had a hearing a few days ago. That very well may be true. The alleged incident date of this protection order violation was the 4th of this month. She had a hearing on the assault 4 case the day prior. In the police report, it states that she was served with the warrant on the 4th, say she had notice of it on the 3rd. Again, I am a defense attorney, obviously, but speaking from my own personal experience, arraignments are a fast-paced, hectic time, and I cannot speak to the depth that the no contact order was talked about. I know for myself and other attorneys, as well as the court, civil standby is blatantly obvious.
Oh, tell us about arraignments, Attorney Lesh.
That's what that means. However, to individuals that are fairly new to this process, it is not so clear. I believe the only prior no contact order where Ms. Klatush was the restricted party was in 2015. That's quite some time ago. The state is also very aware of a very concerning assault 4 case from 2016, in which the individual who under this no contact order is the protected party went to trial, and the state proved beyond a reasonable doubt that Seth, the now protected party, assaulted Miss Schaefer. And that is concerning. In addition, under Rule 3.2, Rule 3.2 has an undeniably strong presumption for release, and that's personal release, unless personal recognizance is not reasonably assured to the appearance of the individual at future court dates, or it is shown that there is a likely danger that the accused will commit a violent offense or cause some risk to public safety. In regards to setting bail, additionally under Rule 3.2, D6 specifically, the court must find no less restrictive conditions than money bail will assure public safety and or non-interference with justice. And the court must consider the accused financial resources, as Your Honor inquired. Ms. Schaefer is currently between jobs. I asked how much bail she could pay, and she said $250. While $10,000 might seem like a little amount to the state, to Ms. Schaefer and many individuals who have public defense appointed, that is a huge amount of money.
Okay, I do hear and I understand pretty much all of what you just stated. I had actually already been considering most of those factors. I am concerned that immediately upon release, we're talking the next day, there's an allegation of a violation. Now, at the moment, that's an allegation. But that tells me that there's a lot of risk potentially to that party, possibly to the public in general, much less so on that prong. But I am concerned about further contact. I am very concerned about Ms. Schaefer being able to return to court. But that is why I was wondering about the financial amount that might be possible. Okay. I do think there needs to be some bail. Ms. Schaefer, I am very concerned that immediately upon release, you headed straight over, or at least within a day. And now there's an allegation, there's a new charge pending, there's an allegation of a violation of a no contact order based purely on you heading over there immediately after. I'm going to put the bail at 1,000 on each cause number to a bonding company. If you can make those arrangements, they would want 100 on each. If you are released, and I'm at the moment thinking it sounds like you will be, you are not to have any contact personally through third parties. If the prior order allowed a civil standby, that means you need to contact law enforcement. If it didn't authorize one, then there really isn't any reason for this. I will authorize a civil, actually, Mr., is it Bredler?
Bredler, Your Honor.
Bredler?
Yes.
All right. Was there a civil standby authorized in the original order?
I will check right now.
Okay.
Yes, a civil standby has been authorized on the original order. Judge Meyer signed it on the 4th.
Okay. I'll put a civil standby on the release order here. Bail 1,000 on each. I will authorize a civil standby. 5/17. And next court date on both of these will be May 17th at 10.
Come on, Judge. We want to see the next one.
Okay, give me.
Go pick up your stuff with a police escort.
This prior order, make sure I have the name right. I am starting with, I can start with 507.
Seriously, call the case
Okay.
before she falls asleep. Or he.
Over
I think it's a she.
Nisqually, we're going to need Mr. Alvarenga in a breakout room with Ms. Langley.
I'm not sure,
And
but it's a good possibility.
The interpreter as well. Or is that at the Ark?
Oh, no, don't call the other guy.
All right.
He is at the Ark.
Is that, I take that back. I addressed Nisqually. I think that is Mr. Alvarenga in the, there we go. Everyone's heading off to Zoom or to the breakout room. That gives me a moment to finish orders.
And Your Honor, I believe that's all the cases that I'm going to be representing today. So thank you for your time, and I'll hop off.
You're welcome. Thank you. I haven't signed those orders yet. You might want to hang on just 2 minutes in case I have a question.
That smile tells me she's not happy to stay for another 2 minutes.
Okay, actually, what I'm going to do is I will leave. So in Nisqually, this is likely Elizabeth Lovato.
Yes.
I see Mr. Pazderka.
Here we go.
On for a first pre-trial. How are we proceeding today?
And Your Honor, we actually have a plea ready. It should be in the judge's folder on Laserfish.
Actually, yes, I do see that. And I do want to indicate, just so everyone's aware, because we have an interpreter on the matter over at the Ark, once those parties return to us, I'm just going to take a break wherever I am and return to that case so we can get the interpreter moving along.
Oh, good Lord. We need an interpreter for all this?
Okay. You are Elizabeth Lovato?
Yes.
Malort may have been involved.
I have a document in front of me titled Statement of Defendant on Plea of Guilty. Indicates the charges are theft 3 and trespass in the first degree. Paragraph 5, there are some rights, such as the right to a speedy trial, the right to hear and question witnesses, the right to testify or remain silent, the right to be presumed innocent, and the right to appeal a finding of guilt after a trial. You understand, if I accept this document, that you are giving up those rights?
Yeah.
Not filled with
There's a
confidence.
recommendation here for 3 days served in custody, credit for those 3 days, and close the case. You understand that I don't have to accept that recommendation?
Yes.
Looks to me as though the citizenship discussion has been had. Is that correct, Mr. Pesterica?
That is correct, Your Honor.
Okay. Porter, come here. Sorry. Ms. Lovato, with all of that in mind, how do you plead to theft in the 3rd degree and criminal trespass in the 1st degree?
Are we going with Mr. Pesterica?
I'm sorry, could you repeat that, Elizabeth?
Were you asking me a question or was it you?
He was asking you how you plead.
I think we said it was already, we said it was guilty. Is that what we said?
Oh,
That's
sweet
what we
Jesus.
discussed is that you would enter a plea.
Okay.
Is that what you would like to do today?
Yeah.
Okay.
Okay. Has anyone made, I'm not entirely clear. Was that you plead guilty to those charges?
Yeah.
Okay. Has anyone made any threats or any promises except what's in this document to get you to make that plea?
I don't think so.
You would tell me if somebody had, right?
Yeah.
Okay. There's a statement here says, on January 3rd in Thurston County, you wrongfully obtained property of another and remained unlawfully in Safeway located at 520 Cleveland Avenue in Tumwater. Is that what happened?
Yeah.
Okay. I will accept your plea. I'll find it's made knowingly and voluntarily with a full understanding of the consequences and that there is a factual basis. Having done so, I'll hear from the state.
Your Honor, the state would just add that this is an agreed upon recommendation that the state feels is the most appropriate resolution. We'd ask Your Honor to follow it.
Thank you. Mr. Pesterica.
Your Honor, we'd also ask that you follow a recommendation. I would note that Ms. Lovato has a number of other warrants. I know in Olympia and Centralia, and I believe one other county. She's aware of those warrants and would like to be able to start addressing those cases. And so I think part of the understanding that she has lots of other cases that she needs to address. And so this is the beginning of a longer process for her.
All right, thank you. Ms. Lovato, you don't have to say anything, but you have the right to address the court before I announce my sentence. Is there anything that you would like me to consider?
No, I just thank you for your service. For your job is important to me. I think maybe possibly. I think. Thank you. Yeah, thank you.
Right. Okay, thank you.
Okay.
Okay, I do intend to follow the the recommendation. I think this sounds, well, sounds like a good way to head with this. Once you are really,
I mean, I don't know. I'm no expert on the topic, but she doesn't seem. I had little, exposure just what's on this video clip, but she seems like she's coming off something to me more so than mental illness. I could be wrong, and if the attorney thinks that an evaluation is the way to go, it's really incumbent upon the attorney to raise that.
at least the case can be closed.
Thank you.
I've imposed 3 days, given you credit for the 3 days you've served, leaving no time left to serve, and so I will be releasing you.
Thank you.
And I've indicated the case can be closed on release. Okay, I have
Tons.
signed that order.
Like right there.
That will be it for today unless either council has anything.
All right, there you have it. I was curious. I want to see her. To her credit, she wasn't all there, but to the extent she said stuff, it made sense. She didn't understand that the judge was asking her to plead guilty, but she got it clarified with her attorney and then pled guilty. But that is a great visual representation of a rough night. It really was. Well, we kicked it all off with Karen filing her own appeal, and then we had lots of other fun. We saw, who else did we see? We saw our good friend Mr. Regier, and then we were out in Washington. I think that's Thurston County for some more hijinks. Thank you all for coming out. I appreciate it. I'll see you soon.